The American Republic finds itself today at a historical crossroads where the legal architecture of power is being fundamentally re-evaluated under the weight of litigation unprecedented in modern history. The recent legal confrontation over presidential immunity transcends the individual figure of Donald Trump, positioning itself as the most significant institutional stress test since the foundational era of the United States and the consolidation of checks and balances. We are witnessing the exact moment when the abstract theory of the separation of powers collides with the concrete reality of criminal accountability, forcing the Supreme Court to define whether the Oval Office operates as a sanctuary of absolute impunity or as a temporary mandate strictly subject to the rule of law. It is not merely a procedural setback for a political candidate, but a definitive judicial mapping of the reach of so-called imperial power and its insurmountable limits before democracy. The current scenario is not limited to a simple defeat in court, but represents the pinnacle of a process of redefining the norms that have sustained the American Federalist Pact for centuries. Historically, the presidency of the United States has enjoyed an almost sacred deference, based on the premise that the leader must make complex decisions without the fear of future judicial retaliation by political adversaries. However, the clash over Donald Trump's immunity has shifted this discussion from an academic field to the center of a latent constitutional crisis, where the legal vacuum between what constitutes an official act and private conduct has become the ultimate battlefield. What we observe now is the desperate attempt by institutions to fill gaps left by the founders, who never anticipated the need to criminally prosecute a former president for actions committed during the exercise of the office's duties. The relevance of this clash lies fundamentally in defining the imperial reach of the modern presidency, in contrast to the principles of constitutional originalism defended by the current Supreme Court. While Trump's legal team argues that the absence of absolute immunity would paralyze the executive and turn every succession into a cycle of judicial revenge, lower courts maintain that such protection would create a caste of citizens above the law. This dilemma places judges in an uncomfortable position where textual interpretation must be balanced with the practical consequences of a precedent that could authorize or criminalize subversive behavior toward the electoral system. The crisis is not about the individual, but about whether the reason of state has insurmountable ethical and legal limits when confronted with acts aimed at destabilizing the fundamental pillars of the peaceful transition of power and popular sovereignty. To understand the magnitude of this moment, it is necessary to analyze the historical trend of expanding executive power that has reached its saturation point in contemporary political reality. Since the Watergate era, the balance between presidential prerogative and judicial oversight has been a constant tug of war, but the system has never been tested so directly. Analyzing these nuances requires technical attention that is essential for anyone seeking to understand the real gears of power in Washington. Therefore, I invite you to subscribe to our channel to follow strategic analyses that decode the hidden movements of the legal system with rigor. If immunity is interpreted too broadly, the presidency will transform into a de facto monarchy. If it is too restricted, the office will lose the agility necessary for governance. The world observes this trial as the thermometer of contemporary institutional vitality. The current legal vacuum reflects the absence of consolidated precedents for dealing with a former president accused of crimes against the state, creating uncertainties that shake confidence in the democratic system. The need for criminal accountability is not merely a quest for retributive justice, but a measure of systemic preservation to ensure that the 2024 precedent does not become the acceptable standard in future administrations. Every decision rendered by the higher courts in this critical phase acts as a structural component in the construction of a new jurisprudence that will govern power relations for decades. We are facing a transition where the authority of the law must prove its resilience against the pressures of populism and extreme political polarization. The outcome of this process will define whether liberal democracy possesses robust enough defense mechanisms to punish misconduct without compromising the necessary governmental stability. The central tension of this clash lies in the direct confrontation between the doctrine of absolute immunity, ardently defended by Donald Trump's team, and the principle of universal accountability, sustained by the Department of Justice. In Poll A, the defense argues that without a protective shield against criminal litigation, the exercise of the presidency would become unfeasible, turning every executive decision into a potential target for future political persecution. This thesis seeks to establish a precedent that shields the decision-making process in the Oval Office under the justification that the fear of subsequent incrimination would paralyze governance and destroy the autonomy of the executive branch. For proponents of this view, immunity is not a personal privilege, but a functional necessity indispensable for the preservation of national authority against the strategic use of law as a partisan weapon of combat. In opposition to this executive shielding, Pole B is represented by the imperative need to maintain the judiciary as the final arbiter of legality in all spheres of public administration. This principle of universal accountability argues that the Oval Office cannot, under any circumstances, be transformed into a zone of impunity where criminal acts are disguised as official prerogatives. The Department of Justice and lower courts argue that the health of the Republic depends on the submission of all citizens, including former presidents, to the rule of law, especially when the acts in question aim to subvert the integrity of the electoral system. The absence of clear limits for presidential power would signal the end of judicial oversight, allowing future leaders to operate above any democratic control mechanism, dissolving the border between legitimate authority and administrative tyranny. What is truly at stake in this conflict is the structural integrity of the system of checks and balances that has sustained American political stability since its founding. This dispute is not merely technical, it is existential for the institutions, as the conflict remains in a state of active boiling, challenging the system's ability to self-regulate without collapsing. If the Supreme Court fails to define a sharp line between the legitimate exercise of function and criminal private conduct, the balance of power will be permanently altered in favor of an imperial executive or a politicized judiciary. The significance of this dispute lies in the perception that the rules of the democratic game are being rewritten in real time under the pressure of a situation that demands a definitive answer to questions that the Constitution left open and unanswered for centuries. The logical progression of this judicial crisis began with the temporal landmark established by the Supreme Court's decision in 2024, which introduced a fundamental distinction previously murky in American jurisprudence. By establishing the dichotomy between official acts, protected by a presumption of immunity, and private acts, subject to criminal prosecution, the court permanently altered the dynamics of the process led by Jack Smith. This initial movement revealed that the court was not willing to grant a total victory to Donald Trump, but rather to create a rigorous technical filter that would force lower courts to dissect every piece of evidence under a new constitutional lens. The decision functioned as the trigger for a chain of events where the defense and prosecution began to dispute every millimeter of the former president's gestures or meetings, turning the legal calendar into a strategic battlefield. As a direct consequence of this new directive, the process faced a period of technical latency while the special counsel reformulated the indictment to fit the court's requirements. This movement of cause and effect evidenced that the defense's delay strategy met an obstacle in the very precision required by justice, forcing an unwanted acceleration behind the scenes of power in Washington. It is fundamental to understand that these procedural details determine the future of the democratic system and I invite you to leave your like if this analysis is helping to clarify the complexity of this unique historical moment. The lifting of the procedural freeze allowed the judicial gears to turn again, signaling that the time for political maneuvers was coming to an end before the need for a concrete legal definition. The transition to the practical application phase revealed that the projected legal invincibility began to show deep cracks. The special counsel, led by Jack Smith, responded to this scenario with surgical technical precision, presenting a detailed dossier aimed at isolating Trump's acts from presidential protection. By focusing on communications with private attorneys and actions aimed exclusively at the election campaign, the prosecution built a narrative where the defendant operated not as the chief executive, but as a candidate seeking private objectives. This tactic implies a paradigm shift. The law stops looking at the office and starts scrutinizing the intention behind the individual action, removing the mist of official legitimacy that previously protected the former president. The presentation of this evidence in lower courts triggered a new phase of litigation, where criminal law began to overlap with the dominant political narrative, forcing the judicial system to validate the premise that delegated authority has clear ethical and legal boundaries. The decision to return the case to the lower courts, specifically under the supervision of Judge Tanya Chutkan, generated a ripple effect that altered the national political schedule. This movement suggests that the judiciary sought to avoid the total paralysis of the system, allowing the discovery of evidence and factual testimony to advance independently of pending constitutional appeals. The reopening of procedural steps signaled that immunity, once seen as an insurmountable wall, had now become a fine sieve through which only genuinely state acts could pass without damage. As a result, the former president found himself forced to confront a court that was no longer limited by the wait for superior directives, creating unprecedented psychological and financial pressure on his campaign structure. The inevitability of a factual trial became the new strategic horizon, transforming every lower court decision into a turning point. In light of this progression, Donald Trump's defense intensified the use of litigation as a strategic delay tool, attempting to clog the system with interlocutory appeals and jurisdictional challenges. However, the procedural mechanics established by the Supreme Court created a funnel that drastically reduced the effectiveness of these procrastinatory maneuvers, evidencing that institutional patience was running out. Every attempt to delay the trial began to be interpreted by analysts not as a search for justice, but as a tacit recognition of the vulnerability of the evidence presented on the merits. This confrontation between the technical agility of the prosecution and the procedural resistance of the defense revealed a tension that consumed immense resources and wore down the rhetoric of victimization. The narrative that the process was merely a partisan attack began to lose technical traction as the facts about post-election conduct gained documentary prominence. The outcome of this chain of events culminated in the perceptible strengthening of the judiciary over the executive, re-establishing the authority of the courts over the individual conduct of the White House occupant. The forced submission of a former president to the ordinary rights of criminal justice indicated that the constitutional architecture of checks and balances still possesses the vitality to self-correct power deviations. By establishing that no act, if proven non-official or purely partisan, is above the law, the system signaled to future leaders that the protection of the office ends where the subversion of democratic norms begins. This systemic consequence transcends Trump's fate, functioning as an institutional warning about the finiteness of immunity and the permanence of civic responsibility before the court. The definitive transition from the stage of abstract debate to factual judgment marked the point of no return in this journey. In the most visible layer of this phenomenon, public perception focuses almost exclusively on the immediate impact on the electoral calendar and the tangible risk of a criminal conviction before the vote. For the superficial observer, Trump simply lost a crucial round in court, moving dangerously close to a verdict that could invalidate his candidacy or result in an unprecedented prison sentence. However, a strategic analysis reveals that the Supreme Court is operating on a distinct frequency, where the priority is not the individual fate of the defendant, but the preservation of the institutional integrity of the presidency as a vital office for national stability. By denying absolute immunity for private acts, the court signals that it is willing to sacrifice the individual Donald Trump to save the institution, ensuring that the prestige and authority of the court remain intact before the rigorous judgment of history. Beneath the surface of technical decisions lies a deep strategic layer that evidences the redefinition of the American social contract amidst the rise of mass populism and institutional distrust. While the strategic analysis focuses on the preservation of the court's authority, the systemic layer reveals that we are witnessing a loyalty test between trust in the ballot box and submission to the judicial system. The court is essentially sending a clear message about the limits of political loyalty within the law, indicating that the ideological alignment of the magistrates does not translate into complicity with acts that challenge the basic structure of the republic. This depth suggests that the legal elite seeks to anchor democracy in foundations that survive any individual leader, treating the Trump phenomenon as an anomaly that must be corrected so that the systemic stability of the government is restored and permanently protected. The global perception of American stability depends on the perceived invulnerability of its legal framework, which is now undergoing a structural transformation under the watchful eye of international observers. At a macro level, this judicial assertion reflects a broad systemic movement to recalibrate the power of the executive branch, which has expanded considerably in the last century. We are facing a historical correction where the state's internal defense mechanisms act to prevent the consolidation of a personalized power model often associated with illiberal regimes. This movement suggests that the American system is opting for a model of defensive democracy, where the rule of law is used as a strategic barrier against the rise of populist influence. By reinforcing that the presidential office is a temporary mandate and not a shield for private interests, the institutions signal that the continuity of the republic depends on individuals. In contrast to these broad systemic movements, the micro-reality of the courtroom offers a granular view of this power struggle through specific procedural decisions and the blunt rhetoric of the magistrates. A clear example occurred when Judge Tanya Chutkan, presiding over the federal case, explicitly stated that the divine right of a president does not exist in the American constitutional framework, a phrase that directly challenged the central premise of the defense. Such specific moments, occurring on precise dates like the reactivation of the trial schedule after the pause for immunity analysis, serve as concrete anchors for abstract theories of national power. Every subpoena sent to former White House officials or the admission of private phone records as evidence represents a tactical victory of the principle of responsibility over the mystique of the office. These specific interactions provide the friction to transform trends. In the strictly political field, the weakening of the absolute immunity thesis casts a shadow of uncertainty over the future of the Republican Party and its internal cohesion strategy. The real possibility of an imminent criminal conviction forces party leaders into an existential risk calculation, where loyalty to Trump's base must be balanced with the electoral viability of a candidate under conviction. This scenario suggests that power structures within the American right may undergo a silent fragmentation, where pragmatic factions seek leadership alternatives while the hard core radicalizes in the narrative of state persecution. If the party chooses to maintain unrestricted support for a convict, the very identity of the ticket will be redefined before the moderate electorate, transforming the presidential race into a referendum on the validity of the criminal justice system, with profound implications for the national alternation of power. In the legal sphere, the consolidation of this new immunity test will create a permanent metric by which the actions of all future presidents will be evaluated by the Department of Justice and the judiciary. The jurisprudence emerging from this critical moment establishes that the exercise of executive function is no longer a blank check, but an activity under constant technical surveillance, which may alter the agility of decisions in national security or foreign policy crises. There is a plausible possibility that future leaders will operate under a regime of excessive legal caution, surrounding themselves with legal consultants to ensure that every official act is minutely documented to avoid future prosecutions. This development signals a transition toward a less imperial presidency, where the fear of criminal accountability acts as an invisible brake on the gears of executive power, redefining the culture of governance for generations. Socially, the implications of this technical decision may catalyze a deep radicalization in segments of the population that perceive the judiciary not as a neutral arbiter, but as a political arm of the existing system. The interpretation of a conviction or a denial of immunity as a judicial coup significantly raises the risk of civil instability and the erosion of trust in fundamental institutions. Regions historically linked to conservative populism may see the emergence of civil resistance movements or institutional disobedience, grounded in the belief that the rules of the game were altered to exclude a popular representative. This scenario suggests that the American social fabric will face a resilience test where the acceptance of judicial truth will be confronted with partisan loyalty. In the long run, the system's ability to pacify these groups will depend on the perception that justice was applied with equity. The great interpretative turn in this legal saga lies in the surprising stance of the Supreme Court's conservative majority, which chose to prioritize institutional longevity over ephemeral ideological alignments. Many analysts predicted that the current composition of the court, strategically shaped by Republican appointments, would offer an absolute safe conduct to Donald Trump's claims. However, the contrast between the expectation of shielding and the reality of the technical decision revealed a deep fissure in the perception of political loyalty within the law. By distinguishing official acts from private acts, the judges not only limited the power of an individual, but also disarmed the narrative that the court would act as a legal arm of the presidential campaign. This change of direction signals that the court's authority is its most precious asset, being protected even if it means exposing a former president to a devastating trial. Another crucial turning point arises when the procedural delay strategy, used exhaustively by the defense over the years, met an insurmountable wall in the surgical precision of the special counsel. What previously seemed to be an infinite labyrinth of appeals and bureaucratic maneuvers suddenly transformed into a countdown, accelerated by the very structure of the Supreme Court's decision. The contrast is evident. While the defense sought the total freeze of actions, the court provided the exact script for prosecutors to move forward with unprecedented speed on non-protected conduct. This inversion of expectations renews public attention by showing that the judicial system possesses acceleration mechanisms that are activated precisely when institutional integrity is threatened by procrastinatory maneuvers. The scenario, which previously seemed stagnant in theoretical discussions, now moves with an inevitability that drastically alters the chances of a verdict before the next cycle. The synthesis of this legal clash reveals that the United States has crossed the point of simple partisan dispute to enter a phase of rebuilding the foundations of its own republic. Throughout this analysis, it became clear that the collision between the doctrine of absolute immunity and the principle of universal accountability did not produce just a procedural verdict, but a new metric for the exercise of executive power. The institutional system, although under immense stress, demonstrated that the architecture of checks and balances still possesses vital mechanisms to distinguish public function from private conduct. The transition from abstract debate to the reality of lower courts marks the end of an era of legal ambiguity, forcing the nation to confront the idea that the Oval Office is not a territory above the law. This expanded understanding allows us to see that future stability depends on submission to the law. Projecting the future, the scenario signals that the precedent established by the Supreme Court will function as a permanent lighthouse for the next generations of American leaders and jurists. The central message emanating from this historic trial is that institutional loyalty to the Constitution must always prevail over momentary political alliances or the pressures of mass populism. We are witnessing the birth of a more monitored presidency, where the transparency and legality of acts will be scrutinized with a rigor unprecedented in modern history. The outcome of this crisis will not only decide Donald Trump's individual fate, but will consolidate the resilience of democratic institutions in the face of existential challenges. At the end of this analytical journey, there remains the clear perception that the strength of a democracy lies not in the invincibility of its rulers, but in the non-negotiable permanence of its fundamental laws.